But it is Tuesday afternoon, a sunny, hot Tuesday afternoon here in Binbrook, Ontario. And I do appreciate you all jumping in. Hey, Andrew. So we are going to restart this little broadcast here. We're going to be talking about the difference between joint tenants and tenants in common when it comes to home ownership. And so I'm just going to fix this up here. There's Stacy back again. Sorry about the little glitch there. We've got to get this all started all over again. Give me a wave or give me a like if you can hear me okay. I got the little microphone going on here. Let me know if you can hear me okay. Is that all good? Somebody give me a like or something, I hope. Hi, Stacy. Waving at me. Awesome. So hopefully y'all can hear me all right. If not, please let me know. But we will be looking at, again, joint tenants versus tenants in common today. So the laptop is out of commission. That's what I'm going to presume for now. And we're just going to have a chat. It's a very informal chat. And as I usually say, there's always disclaimers that go with all of these different types of broadcasts that I do. So just so you know, everything that I speak about today is my opinion based on my experience and my knowledge, having worked in real estate for about 6.5, almost 7 years now. But I am not a lawyer, so please don't take this as legal advice. If you do need legal advice, you should contact a lawyer, and I'd be happy to put you in touch with either real estate attorneys, litigation attorneys, all kinds of different lawyers I can put you in contact with if you like. But we are going to be having a chat about joint tenancy versus tenants in common. It is a very casual chat. You can really do a deep dive into it and look at court precedences and all of the legal ramifications and all that sort of stuff, which is not what we intend to do today. Definitely I am more than happy to have those type of conversations with you. So if you want to know, please feel free to get in contact with me here on Facebook. But today's conversation is more of sort of a high level, just general explanation about what it is, how it works, how it impacts your ownership of a home, what happens when you want to sell the property, what happens if someone passes away, and all that sort of stuff. If you have any questions, please feel free to put them below. I do see all the comments popping up. I can see Christian and Sean and Sonia. If I pull out my romper room mirror, I am sure I could see everybody. But I don't have one with me at the moment. So if you do have questions, please feel free to put them below. But generally speaking, let's start our little chat. We are looking at the difference between joint tenants and tenants in common. These are two types of ownership that can happen. And generally speaking, we're going to be talking about property ownership today. So when you go to purchase a property, generally speaking, if you're the only person that's owning the property, this doesn't really come into play at all. When this really comes into play is if you're purchasing the property with other people. And most often that happens between couples who are married or common law or living together or some sort of couple. And again, this doesn't exclude any specific type of couple. It could be man, woman, two men, two women, you name it, whatever. It could be brothers and sisters that are buying a property together, friends that are buying a property together. Anytime when there's more than one person who has ownership rights of a property, you can have that ownership in a couple of different ways. One of them, or the most common, is joint tenants. So again, just drawing from my own experience and what's usually most common, if you have a couple, a married couple, for example, or just a couple that's living together, raising a family, most often the default type of ownership is joint tenancy, and that's what lawyers will default to. Most lawyers that I've dealt with won't even, generally speaking, ask the couples if they want to do a tenants in common type arrangement. It's just sort of an understood thing that joint tenants is the default position. What that does is that gives both owners or all the owners of that property, if there are more, but in the case of a married couple, it gives all the owners equal ownership of that property. Now that does not mean 50-50 ownership. That means that both people that own the property, for all intents and purposes, own 100% of that property all the time. As far as your ownership rights are concerned, you can't be excluded from any part of that property. So if you are a joint tenant on a property, you have access to that full property. There are some other interesting situations that arise. I think most recently, the thing that probably most people don't know is I saw a newspaper article. I believe it was from here in Canada. I think it was the Toronto Star, the Globe and Mail, or one of those newspapers, that even beyond the joint tenancy or tenants in common, just property rights in general, if someone were to leave something on your property, and the example given, I believe, was the neighborhood kids who were, riding their bikes past somebody's house and dropped off their bike on the front lawn, and then the person who owned the property took the bike. And the question arose as to whether they could legally do that, and apparently they can. So anything that's on the property that's left there by people who enter your property, technically speaking, becomes the property of the owner, of the people who own the property, at least so far as I understand it. Again, I'm not a lawyer. Seek legal advice if this happens to you. Personally speaking, if you're taking a neighborhood kid's bikes or balls or frisbees or tennis rackets or whatever they happen to leave on your lawn as they run by and have fun playing in the neighborhood, I think you're a jerk. You probably shouldn't do that. I mean, I understand you're getting upset and everything, but taking their property is probably a step too far, in my opinion. So going back to joint tenants, that was a little bit of an aside there. You own 100% of that property. So for myself, I used to be married. I had a wife, and between the two of us, we both owned 100% of that property. So what does that mean in legal terms? So in terms of putting out a will, people will fill out a last will and testament. What happens is, you write up a will. Now, in terms of joint tenants, in terms of the property, you really don't need to assign property rights. If you are a part of a couple or part of a group that has joint tenancy over a property, when the one party passes away, which is what a will is for, the property rights immediately transfer to the other person. So in the case of a married couple, a husband and wife, if the husband were to pass away, the wife becomes the 100% sole owner of that property. So you cannot will your part of the property to anybody else. So if I wanted to write up a will saying that my portion of my house will be willed to my children in the event of my death, you could do that. You could actually write out a will that says that I want my house to go to my children. However, once I pass away, if my spouse is still surviving, I no longer own anything. I have 0% ownership over anything. It all goes to my surviving spouse. And at that point, there is nothing to will to my children. So yes, they get your share in the property, but your share of the property is 0. So they get their percentage share of 0. So technically you're carrying out the instructions of the will. There's just nothing to give out. It'd be the same as if you had money in the bank and you said that upon my death, my children were to get the money in the bank, but you spent all the money before you died. Like there's nothing there. So technically they get 50% each of 0, which is 0. So that's what happens under joint tenancy. And the same happens when you're going to sell a property. You both have equal ownership of the property. Generally speaking, if you both have to sign, so if you're both on title, you both have to sign the documents to put the property up for sale, for when it's sold, etc., because you're both equal owners of that property. If you were to get a divorce or separated, again, you're still both equal owners of that property. Aside from situations where there may be threat of violence or physical abuse or just harassment and that sort of thing, which is a separate issue, neither party can tell the other party that they have to leave the premises. You both have equal rights to the premises. And you might want to take into consideration that you do have equal access to all of the property. So even if you were to tell your spouse that you don't want them to enter a specific room in the house or a floor in the house or any of those type of arrangements, aside from there may be other legal precedents for this. So again, speak to a lawyer to find out what the actual rulings might be in this type of subject. But generally speaking, under joint tenancy, you cannot exclude the other owner from any part of the house. They have 100% equal access to it. So then you dispose of the property and you split the proceeds 50-50 or whatever type of arrangement you would come to. So that is different than tenants in common. In a tenants in common situation, you actually do own a specific portion of the property. So in a tenants in common situation, the most common example that I can give is when a number of people get together to do things like buy a vacation property. So a bunch of children may own part of a cottage, the family cottage up in Muskoka or up north somewhere, and you may have a brother and sister. So the brother and sister may own the property as tenants in common. They may both own 50% of that property, or they may own 75-25, 60-40, whatever their arrangement might be. So they might decide to get together, like a bunch of brothers and sisters, or a bunch of friends might decide to get together and purchase a cottage up north. A really expensive cottage might be $1-2 million. And as a secondary property, you might not be able to do that unless you're in a group. So 2 or 3 different families might get together and pool their resources and purchase it. And they'll purchase it, normally speaking, as tenants in common. So if you have 3 different, or say 4 different families or 4 brothers and sisters getting together to buy a cottage, they may own 25% of that cottage each. Again, depending on any side agreements that you might have, hey, we'll see you later, Stacy. Depending on any side agreements that you might have, you generally speaking have equal access to the property. Again, unless you come up with a contract that says, family A will have access to the property a certain time of the year, family B another time of the year, or family A can occupy the top floor, family B can occupy the middle floor, etc., and that sort of thing. Generally speaking, you have 25% ownership but 100% access to the property unless there's a secondary agreement in place to modify that. Now, when it comes time to sell the property, so if one of the owners decides, one of the 4 brothers and sisters decide that they no longer want to own a part of the property, they want the funds from the sale to do something else, or if one of them passes away, that's where the joint tenants versus tenants in common really differs. So as a tenant in common, that brother or sister could actually write up their will so that their children, so the children of that brother and sister, would inherit that 25% of the cottage upon their passing away. So in their will, the estate actually takes possession of that 25%, and it's willed to or divided up amongst the children of the surviving children of the person who owns that portion of the cottage. And any rules already in existence that would apply to that 4th brother or sister would then apply to their children who took ownership of that. Now, a lot of times in a joint tenant situation, there'll be a secondary contract in place whereby if one of the people wanted to leave or sell the property, or one were to pass away, that things would automatically happen so that the other 3 owners would purchase that 4th property, or at least they would have first right of refusal. So they could make an offer to buy that 25% stake as a group or individually, so that the ownership stays within that group. There is a situation that could arise where, it's a family situation or a friend situation. People tend to go their separate ways. They have arguments, and that 4th brother or sister might just want to sell their share of the property to a stranger. And then the other 3 brothers and sisters would end up owning that cottage with just a random person that they don't know. So they want to avoid that, so they come up with a secondary contract to modify the terms of the joint tenancy. But with the joint tenancy, as I mentioned, the estate inherits the property, and you can will it to someone else. You can sell it to a third party if you wanted to. Again, unlike a joint tenancy situation where there's survivorship benefits, basically, and the ownership would transfer to the other owner, the spouse, brother and sister, what have you in that situation. So that's a basic explanation of joint tenants versus tenants in common. That is what the difference is between those two in a very casual, very sort of top level explanation-wise type deal. Again, you can get into a much more deeper discussion about what the differences are, what the legal ramifications of ownership are, what the taxation ramifications for ownership are, and all that sort of stuff. But again, that was just a primer. If you do have any additional questions, please feel free to contact me here. If you are in that situation and you're seeking legal advice, I can always refer you to a real estate lawyer or a litigation lawyer, or any type of legal counsel that you might need to get advice specific to your situation. I'm always happy to help. Sorry that the computer kind of crapped out on me at the beginning there, but next time we'll get it up and running again. But for the rest of the day today, I am the Geeky Agent from Hamilton, Ontario, Canada. I hope you have a great rest of the day and rest of the week, and I'm sure before the week is over, I'll talk to you soon. Bye for now.